Hello everybody, I hope you are well. If you are buying or selling a pre-owned property, there will inevitably be what we call a footstool clause in the sale agreement. It's very important as a buyer and a seller to understand the meaning and the consequences of this clause so that it doesn't lead to unnecessary disputes later on. We're going to unpack this for you now in layman's terms so you understand what it means. Right, so the term footstool comes from Dutch law. Literally translated, it probably means with a shove of a foot. There's your property with a shove of a foot. But what it means is that you as a buyer are buying the property as is, as it lies, with all defects. So defects in a property can be classified as either a latent defect or a patent defect. Patent defects are defects that you can see with a naked eye. So with a reasonable inspection of the property, while walking through, you would be able to see this defect. Maybe just a cracked tile or something like that. Anything that you can see when you're walking through the property. So it is important that you do a reasonable inspection of the property before you make your offer so that you can see any defects, because they will just be included in the sale and you will not be able to hold the seller liable for any patent defects. Latent defects, on the other hand, are defects that you can't see with a naked eye. So let's say it's a faulty geyser maybe, or a faulty pump, or there is damp on a wall but it's behind a large cabinet which you can't just move with a reasonable inspection. Those are latent defects which you can't see. So in certain instances, you would be able to hold a seller liable for latent defects, but only if firstly the defect did exist at the time of the sale. So a buyer would have to prove this in a court of law in order to get a seller to be liable for a latent defect. He would have to prove that the defect did in fact exist at the time of the sale, and he would also have to prove that the seller did not disclose this defect to him, although he was aware. So you've got to prove the seller was aware of the defect, and you've got to prove that he purposely didn't disclose the defect to you. So those are the only times you would be able to hold the seller liable for a defect. So on face value, the footstool clause protects the seller from all defects in a property, but bear in mind that the courts will not protect a dishonest seller. So in certain instances, if there's a latent defect that the seller was aware of and he didn't disclose this to the purchaser, he would be able to be held liable for that. Right, so to summarize, if you're a buyer, please make sure you do a decent inspection of the property and acquaint yourself with the condition of the property before making an offer. If you're a seller, please take a bit of time before marketing your property to sit and think about any possible latent defects which are not clearly visible, which you may be aware of. Make a list of those and we can declare them to potential buyers. Let's just do the right thing, keep it honest, keep it out in the open. So that's it in a nutshell. I hope that was of some help to you. If you do have any further questions, please don't hesitate to ask us. In the meantime, until we chat again, go well and stay safe.